Mr. Kinnan.
My lady, my lords, I finished just before the lunch journey making the negative point that my learned friend's interpretation of the clause was unlikely, undifficult, awkward and unworkable. I'd like to turn now to the positive point of why we say our interpretation is the natural meaning of the words on the page. Now, we say straightforwardly that the natural meaning of the words imports two things. One is that the MRC and the facultative certificate are to be read together. And the second is that there is a hierarchy between them, with the MRC being given precedence. And we say this is so because of both the language and the syntax of the clause. So far as the language of the clause is concerned, we say that the phrase takes precedence over necessarily requires two documents to be read together. One thing can only take precedence over another if they are being considered together. We also say further that it's implicit within that phrase that when those two documents are considered together, they may cover the same subject matter. So, in other words, takes precedence over itself imports a suggestion that there may be conflict. And so the entire clause has to be read in that way. And so to some extent, takes precedence over can and does inform the meaning of confusion. The second point is that straightforwardly, it's the MRC which is given precedence. Now we say again, straightforwardly,
the MRC is the slip.
It is, yes. I'm sorry, I have been calling it an MRC for 2 years, but I will try and refer to it.
It's all right, I'll try and remember which is which. It's just that they both begin with M, which is what confuses me, because the other one is the MUR, is it?
Yes, the Neura. Although I think we're today calling it the facultative certificate, or the certificate. But, yes.
So the slip is given precedence over the certificate.
Yes, precisely. And that is clear on its wording. And indeed, even on GIC's construction, in the circumstance in which there is confusion and one looks at it, it is being given precedence. So that is inherent within the phrase. We also say that the structure of the clause suggests that the proper and sensible interpretation is that the confusion is between the two documents. And that is because the clause starts by referring to the two documents and identifies their relative importance where there is confusion. Now, we say that GIC haven't really engaged with these positive points of construction. And really, its rebuttal on the language of the clause focuses only on the word confusion in isolation. And its case is essentially, at one point, really boils down to simply an assertion that if the parties had meant inconsistency or conflict, they would have used inconsistency or conflict. Picking up a point that my Lord Justice Nugee made just before lunch, we say that even if it were permissible to ask if they could have phrased it in a different way, that is in essence a submission of saying, well, generally people use that word. That might be a word that is known to lawyers who draft the clause or the like, and so if they'd meant it, they would have used it. But we say the proper exercise is to say, what did they mean by the words they in fact used? And we say that it is an approach that is wrong as a matter of construction to say, could it have been phrased differently or could it have been phrased better? And my Lady Justice Asplin, in European Film Bonds and Lotus, made precisely this point. My learned friend alluded to it, but didn't take the court to it. It's in volume 1 of the authorities bundle, at the back, tab 10, and the relevant part is on page 225. It's in paragraph 52. And this case concerned the construction of a completion guarantee in relation to film production, and the guarantee paid out if the film was not completed and delivered on time. And the question was being addressed at paragraph 52 was the meaning of the word returned. And there was a dispute whether that was satisfied by entrusting the film to a courier, or if it had to in fact be delivered to the respondent. And the argument that was made was that if the parties had meant receipt by the respondent, they would have used the word deliver rather than the word returned. And my lady gave that argument rather short shrift. At the bottom of paragraph 52, starting with "for similar reasons," and it said, "For similar reasons, I do not attach weight to the suggestion that physical delivery into the respondent's possession was what was required. It would have been simple to say so. The question for the court is the contract entered into, is what the contract entered into by the parties means, not whether it could have been better or differently expressed." And I think my learned friend tried to reduce the significance of that by saying it didn't really follow from what was said in the interpretation of contracts in Lewison, but it is something that finds favour in other cases as well. So for instance, in the bundle here in Amtrust, at paragraph 64, the point is made as well, and that really picks up the point that I think my Lord Justice Miles made earlier, which is that one can always have the reverse. One can always say, well, you could have said it this way, but I could have said it this way. The fact that we are before the court having a dispute on construction rather suggests that there might be a different way that one could have put it.
But as you looked at the cases that came before the court, you would think that all contracts were ambiguous. But there must be plenty of contracts which are perfectly well drafted and we've never seen.
Well, precisely, and I do remind myself that I only see the ones which potentially are ambiguous. But one assumes that business gets on without lawyers quite happily, and for the most part.
We don't have this. We've got a bit of Lewis, and we don't have this bit of Lewis.
We don't, I'm afraid, no. So we say, in essence, the argument and the nub of the argument the GIC make, that if they'd meant conflict, they would have said conflict, is not one that is open to my learned friend to make. But in any event, we say that confusion is an apposite word to use. Confusion can arise where there are two clauses within a contract which is inconsistent. And where one pairs confusion with the phrase take precedence over, we say it's clear that the parties were considering that there might be a conflict between the two because they were in fact being read together. Now, in the skeleton argument, it said that the judge's conclusion that confusion can encompass inconsistency or conflict was unfounded assertion unsupported by authority, dictionary meaning, or common usage. But that, we say, is also wrong, because there is support for the judge's conclusion by the way the word confusion is used in the case law before the court on this very topic. They're cited at footnote 28 of our skeleton argument, but it's convenient both find their way into Surrey and Suez. That is in tab 11 of the authorities bundle, which is volume 2 of the authorities bundle, and page 244. Paragraph 61, there is a quotation from Sul America, at first instance, the judgment of Mr. Justice Cook, where he explains, although it's possible for parties to agree that quantum should be dealt with in one jurisdiction and liability in another, this was addressing the argument in Sul America that the arbitration clause went to quantum only and liability went to court. The two are not always clearly distinguishable, and all the authorities reveal a reluctance on the part of any court to decide that certain types of dispute be dealt with in one forum and others in another, because the parties are most unlikely to have intended that. since that would be a recipe for confusion. Similarly, at paragraph 98 of the same judgment, that's on page 252, Mr. Nissen, KC, talks about confusion between jurisdiction clauses, or dispute resolution clauses, and says if Surrey were right, it would not be difficult to imagine examples of cases in which there would be confusion and uncertainty about the appropriate forum for the resolution of a dispute. So we say that the use of the word confusion to identify inconsistency or conflict, and particularly to identify inconsistency or conflict between a dispute resolution forum, is a perfectly natural use of the word. Now, Mr. MacDonald-Eggers attempted to define what confusion might mean in this particular clause, and an example that was given was the conflict between Arkansas law and New York law, which it was said was then default to English law. Now that, we say, is clearly an inconsistency. That is a conflict. So the very way that my learned friend defines confusion clearly does encompass conflict or inconsistency. Likewise with the example as to different payment dates on premium. Those were themselves examples of conflict or inconsistency. So we say even in my learned friend's definition, confusion does encompass conflict or inconsistency. So we say even if one were to focus on the word confusion in isolation, it does its job in the way that we say it was clearly intended by the parties to. Now, as to the suggestion that the confusion is not that between the two documents, as far as I understand it, the objection made by GIC has two parts. First, it said that the clause would require a rewrite, and second, it said that the parties are said to have agreed by the entire agreement clause that the MRC was superseded. Now, the first is, I think, in my first category, so pure construction of the words used. The second is an extraneous one, but they go to the same point, so I will deal with them both together. Now, as to the first point, the proposed amendment to the clause suggested by GIC is at paragraph 35 of their skeleton argument, and that is in the core bundle at tab 4, page 28. And it said against me that if one intended the two documents to be read together, one would add the words in underline at paragraph 35. So at the end of the clause, one would add the words between the RI slip and the reinsurance certificate. Now our point is, well, they could be added, and the clause would still mean the same thing, but they don't need to be. Because the fact of its syntax, the fact of it referring to taking precedence, does that job already. The fact it refers to both documents and then identifies confusion as the trigger point. On the other hand, and this is perhaps rather making good the point, that if one says you could have expressed it differently, the other says, well, you could have expressed it differently, we say that if GIC is correct, that does require words to be added. It requires words to be added to override the natural inference of take precedence over and the reference to the two documents. And we've set that out at paragraph 28 of our skeleton argument. But essentially we say that one might need to say RI slip take precedence over reinsurance certificate in case of confusion on the face of the reinsurance certificate when read in isolation. That might do the job, but even then we say it wouldn't be particularly obvious. But without those additional words, we say the natural inference is clear and the natural meaning is clear. And we do say it's telling as well that my learned friend, and I say quite rightly, doesn't put his case any higher than saying that his interpretation is capable of working as a matter of the language. Now we say that's wrong, even that puts it too high. What my learned friend doesn't say, and quite rightly, is it's the natural meaning of the words. And that, after all, is what primarily we are here to determine.
Do you go so far as to say that the words "in case of confusion" are unnecessary? If you just had RI slip to take precedence over reinsurance certificate, would that have the same effect?
Yes. Yes, I think it would. And that is why, in the prior year, the policy simply said one was subject to the other. It didn't actually identify. And that's part of why we say, because take precedence over itself already imports the idea of conflict or inconsistency.
Because if they're consistent, you don't need to decide which to use.
Precisely. And so in the prior year, we simply said one was subject to the other. We say one taking precedence over the other is the same. In case of confusion, we say, contrary to my learned friend makes it clearer, this is clearly a hierarchy clause. This is clearly to deal with conflict, inconsistency, something that's indistinct or obscure. But it would work without them. So turning then to the next point, which the learned friend relies on the entire agreement clause, we say again that takes matters no further. That is at Supplementary Bundle tab 5, page 128. So the heading is at the very foot of page 127, clause 26, entire agreement. The body of the clause is at the top of the next page, left-hand column. Now, the entire agreement clause, we say, in fact, expressly preserves the slip as part of the agreement, because it says this agreement, and the agreement is defined as the certificate. That is a defined term on the front page of the agreement, including any duly executed written amendments, endorsements thereto, and appendices, schedules, or other attachments made part thereof or expressly incorporated by reference. So we say that because, first of all, the MRC was endorsed by the facultative certificate, the MRC is part of or encapsulated within the entire agreement clause.
I'm sorry, I'm interrupting you in the middle of a sentence, I know. Are you going to explain how the endorsement works? We heard reference earlier to something called GIC Re. Yes. I'm not sure I have a very clear idea of the mechanics by which these two documents came
Certainly.
to sit together.
No, of course, my lord. I can do. I plan to make some submissions on the endorsement, and we'll turn to it then, and perhaps I can go through it.
I don't want to take you out of your course.
No, thank you.
It's just you addressed us as if that was something you'd already established, which, for my part, I haven't quite got my head around.
No, quite right, and I will make sure I turn to that. My lady has, of course, had my quite extensive submissions in Partner Re as to when the endorsement wasn't followed, what the impact of that was, but I will pick it up when I go there if that suits.
By endorse in this submission, in the one you just made, do you just mean it's referred to on the first page of the agreement? Was that the point you were making?
No, my lord, it goes slightly further than that. So that is the second point I was just about to come on to.
I don't want to anticipate.
It is, I say that it either falls within the category of amendment and endorsement thereto, or it falls within the category of expressly incorporated by reference. It's one or the other, or it could be both. But it is, in any event, we say clear that the entire agreement clause is not intending to supersede the MRC, because the MRC has itself been endorsed by the facultative certificate. So the two have been made into one, but also because the confusion clause itself refers to RI slip, and on the face of the facultative certificate, if one turns back to page 121, it has the agreement number, which is the agreement number of the MRC. So we say there are two ways that one gets to the same results. Both stand true, but I only need to succeed on one. We also make the point that the prior year, in Partner Re and in GIC, also had an entire agreement clause. And that was something that was argued before the Court of Appeal last time, and that did not stop Lord Justice Mayles from concluding that in the prior year, the slip, the MRC, nevertheless continued to have contractual effect and was not ousted by the entire agreement clause.
Was that something he had to decide, or was it just background?
No, it wasn't. Well, it wasn't. It wasn't ratio, my lord.
There wasn't a claim for, under the prior year?
No, there wasn't. It was relied on by both parties as background factual matrix, the interpretation of the next year. There was no claim under that contract. So we say that the entire agreement clause does not undo what is otherwise clear on the face of the confusion clause, because the entire agreement clause itself anticipates that there might be more documents than simply the facultative certificate, which the parties have nominated as contractual documents, and we say that is precisely what they did here. So moving then to my learned friend's point that the factual background against which the confusion clause must be construed is that the MRC has been entirely superseded. Now, we say that that is wrong. We say as a starting point that presupposes the effect of the clause. My learned friend suggests that the support for that approach comes from Partner Re. But as I've already made my submissions on, we say that this case is different from Partner Re, and indeed the judge below and Mr. Hancock agreed. And that is because of the confusion clause and because of the fact of the endorsement. So it's artificial to say in Partner Re it was superseded, and so that is the starting point here. One needs to interpret the words of the clause to see what they mean, and then apply it against the factual background. But in any event, there is also the point that against the factual background, even if one were to put to one side the question of whether, in Partner Re, whether that approach is relevant, we also have the additional point here that I set out at the outset, that if one does entirely supersede the MRC, then the specific clauses of the general change endorsement in the Beazley policy are themselves lost. So it isn't the case that one says all of the factual background...
Can you remind us of some examples that are in the Beazley policy but would not be in the certificate?
Of course.
And whether they're, if I can put it this way, are they boilerplate or are they significant?
So
it was contagious diseases, wasn't it, for example?
Precisely, my lady. So infectious contagious diseases, which, of course, at the time this policy was written, 2020, 2021, or sorry, 21, 22, was very much in the forefront of people's minds.
But also, Tyson Foods presumably has livestock.
I'm not entirely sure whether they arrive alive or not. I may be able to get instructions on that.
But there are, I mean, one is aware that there are contagious diseases of animals which can have very serious financial consequences for those involved in food production.
Yes, absolutely. And of course, those contagious diseases can be transmitted, as I understand it, by animals that have already been slaughtered, so E. coli and the like. So we do say that that was a specifically agreed endorsement. That was something the parties clearly intended to have effect. And we say that is something, if one is looking at this in a background factual matrix way, that would tend towards the MRC not simply being jettisoned, because it's only if the MRC is preserved and continues to have contractual effect that those clauses would continue to have contractual effect. If it's simply the underlying original insured policy, I'm sorry, I used original insured, if it's only the underlying insurance policy that applies, the general change endorsement does not. So we say, even if one puts to one side the Partner Re approach, and one looks at this neutrally, there are factors that in fact point the other way. When one brings in Partner Re, when one brings in the natural language of the clause, we say it's really beyond doubt, and the factual matrix supports our case and not GIC's. The next point that my learned friend makes in his skeleton, it wasn't really pushed orally, is a reliance on HIH casualty. This was another film case, insurance policy on investments that were made into film production. And what my learned friend says in his skeleton is, and I think perhaps maybe in a tacit recognition, that it might be thought to be a little unusual for one to go back to a superseded policy in order to resolve confusion, whatever confusion may mean, says, but actually this is something that the courts have done before and refers to HIH for support. Now we say that if one looks at HIH, it lends very, very mild support to that proposition at its highest, but in any event, as the judge found, is distinguishable in these circumstances. It's paragraph 83 of HIH that my learned friend refers to in particular. That is in Authorities Bundle Volume 1, tab 2, page 60. Now, in this case, there was an insurer claiming against reinsurers in respect of a reinsured pecuniary loss policy, in respect of investments in films, and one of the questions concerned whether a particular warranty concerning the number of films had been incorporated into the reinsurance. And as part of that argument, resort was made to the slip policy, and that was then, in the old way, subsequently superseded by a full policy wording. That, of course, as we set out at the outset, and as I think Mr. MacDonald-Eggers agrees, is no longer the way that these things are dealt with. Now, in the context of referring to the utility of the slip policies, Lord Justice Ricks said at paragraph 83, in principle, it would seem to me that it is always admissible to look at prior contracts as part of the matrix or surrounding circumstances of a later contract. He goes on to say, and we say this is the important bit that qualifies this, the difficulty, of course, is that where the later contract is intended to supersede the prior contract, it may in the generality of cases simply be useless to try to construe the later contract by reference to the earlier one. Ex hypothesi, the later contract replaces the earlier one, and it is likely to be impossible to say that the parties have not wished to alter the terms of their earlier bargain. The earlier contract is unlikely, therefore, to be of much, if any, assistance. So we say my learned friend puts the point too high to say it finds support in HIH. We say it is still rather unusual. It would be an odd state of affairs if the parties would agree to supersede a contract, but then to somehow resurrect it and bring it back to life in the case of confusion. And we say that HIH doesn't really, with any enthusiasm, lend support to that approach. In any event, in HIH, it was found that if the slip policy had not been superseded, so that was in any event obiter, and as the judge noted, there are, of course, matters that distinguish HIH. First of all, that HIH did not contain a hierarchy clause. And second, sorry, as I've just said, that the slip policy was not superseded. So we say it isn't an apposite comparison, but even if it were, it is, even at best, a lukewarm suggestion that this might be an approach that the parties might use.
I mean, it might be thought that what Lord Justice Ricks says there, it might be thought it's actually slightly in your favour, because as I understand the appellant's argument, they're really saying that the earlier contract, which would otherwise have been superseded, is being used as some sort of tool to construe the later one. Although I suppose they did go further than that, and perhaps that's why they say that it does actually have contractual effect in that case. But just in terms of the idea of using it to construe the later contract, the point made by Lord Justice Ricks is it may not really be of any use.
Yes, precisely. And we say that is in our favour, because we say...
But I suppose that, in fairness, the appellants did say, no, it's not just a construction point. It does continue to have some contractual life.
I must confess I wasn't entirely clear on what that contractual life was, save that it was used to clear up confusion.
Seems to be the only contractual life it has. It doesn't have any other contractual life. It can sort of spring back into existence where there's confusion, it seems.
That is what I understood the submission to be.
To provide an answer where there is no other source.
Yes. Precisely. And of course one might make the submission, well, if that is what one is able to do anyway, then why would one have a clause identifying that? But we say the bigger point is that, as Lord Justice Ricks points out, it's not really going to be of very much use. And so that is the point that the judge below made as a matter of commerciality. Is it likely, as a matter of commerciality, the parties would have provided for this? Or is it more likely they would have provided for a mechanism to resolve inconsistencies?
I have to say, I mean, it doesn't really matter, but for myself, I think Justice Ricks protests a bit too much. If you have an ambiguity in a later contract, it could mean A and it could mean B. It might be very helpful to see what the parties agreed when they agreed an earlier version of what is the same transaction. It might make it entirely clear whether they meant A or B. Slightly reminiscent of whether you could look at negotiations, which is something that Lord Justice Miles and I know about. But this sort of absolutist thing, saying if the wording's the same, it doesn't add anything. If the wording's different, it's obviously different. It seems to be a slightly reductionist view of the world.
Well, of course, what one might say that this is really just potentially rectification by the back door. But of course, that would be a different way to approach it.
But you say that passage is obiter anyway.
We do. We do, obiter and distinguishable.
And in any event, it's not really what is being suggested by Mr. Donald Davis. He's not saying that if you have a clause saying it could be the 1st of September or it could be the 28th of September, you can use the prior contract to resolve that difference. He's saying you can use it to displace that and substitute the 15th.
Yes.
And that's not construction at all.
No.
That is using an earlier document effectively as a tiebreaker, as my lady said.
Yes.
But I'm not sure that Lord Justice Ricks is dealing with that at all.
No, and that wasn't the point before him in this case. So that then brings me on to Mr. MacDonald Davis's point on other terms of the facultative certificate. What's said here, and much emphasis was put on the fact that one of the lines in the facultative certificate refers to the terms that are listed beneath it as required terms and conditions. If one goes to the supplemental bundle, tab 5, page 122, my learned friend made much of the fact that terms 1 to 26 are headed required terms and conditions, and 27 to 30 are headed additional terms and conditions. Now, I think that my learned friend was trying to suggest or make a case that the fact that they were required somehow made them more important, or somehow made them negotiated. I think both points were alluded to. Now, we say that that is making that heading do far more work than it can properly bear. We say that heading is simply distinguishing between terms that are generally applicable and terms which are applicable only in certain circumstances. So if one looks at, for instance, the intermediary clause, which is an additional term and conditions brackets if applicable, clause 28. That is I'm sorry, if one looks at clause 30, page 129 in the same tab, suspension of insurance, brackets if applicable, it sets out, for instance, applicable only to reinsurers which also provide boiler and machinery inspection services. So they're saying within this standard form there are certain terms that apply only in certain circumstances. The rest of them are just part of the standard form. And so insofar
So you're
as...
saying 1 to 26 are standard form?
Yes. Yes, my lady. And in fact, that's the description given to them in Partner Re, the Court of Appeal, for instance. So if one looks in the Authorities Bundle tab 13, which is in volume 2, page 266, and paragraph 7, which is in the right-hand column, just above the reinsurance programme, says, like the MRC, the MURA contains standard headings, in its case for, among other things, the coverage, the reinsurance period, the reinsurer's participation in the applicable terms and conditions, some of which are described as required, while others are optional. That follows from paragraph 5, the description of the MRC, which describes how the contract form contains initial pages, the risk details with headings on the left-hand side covering such matters as the unique market reference, the type of risk, the period of cover, the sum insured, the premium and payment terms, the party's choice of law and jurisdiction. These are then completed on the right-hand side of the document. And that's a point that the judge below picked up. In the MRC, the headings are standard, but the content of the clause is populated by the parties. In the MURA, the terms are themselves standard. And then at paragraph 24, just to make good that point, which is at page 288. I'm sorry, I think that is a bad reference.
What are we looking for?
Paragraph 24 of Partner Re.
Oh, Partner Re, sorry.
I think that's 268.
It is.
And that refers there, this is talking about the MURA, clause 3 of these standard terms provided that the reinsurer's liability would. So, my learned friend put a lot of stock in the phrase required terms and conditions, but that doesn't, we say, do anything to change standard pre-printed terms from anything other than standard pre-printed terms.
Does required, therefore, really mean applicable in all cases, and optional means applicable only in certain cases?
Yes.
Not optional, additional.
Precisely. And as I said, as was found in Partner Re and as the judge noted below, it was judgment paragraph 74, subparagraph 5, the choice of law and jurisdiction clause in the MRC is a matter of choice for the parties. So even if there was no confusion clause, we say that there would be an argument to be had if one accepted that both documents continued to have contractual effect as to whether one took precedence over the other. In other words, the particularly crafted clause as opposed to the pre-printed standard term. The next point that my learned friend referred to was the premium payment date. And this point is said to arise because the MRC included, the slip included a clause which provided for payment of premium by the 28th of September. And we can see that in the supplementary bundle, tab 1, page 24. And that provides that it's a condition of this contract of reinsurance that the premium due at inception must be paid to and received by reinsurers on or before midnight on the 28th of September 2021. And my learned friend notes, as he did before the judge below, the facultative certificate at tab 5, page 122, provides for a premium payable date of the 1st of September 2021. Now, we say that there are 3 ways, and my learned friend's submission, as I understood it, was essentially to say, well, this is a specific amendment on the face of the facultative certificate. It would be undone by the confusion clause if the judge's interpretation of the confusion clause were correct. Now, we say 3 things to that. We say, first of all, that is not necessarily so, because one can construe the 2 clauses together. The test, as we'll come on to in ground 2, is whether there is a conflict between the 2 clauses. If they can be fairly read together, then the court will construe them as such. And we say, and obviously this isn't a point this court has to decide, but we say if one were striving to read these 2 together, one could do so. And that is because the premium payable date in the MRC of the 28th of September carries with it, as we saw, an automatic termination if not paid by that date. On the other hand, the premium payment date in the MRC, and that is clause 12.
You don't mean the MRC.
I'm sorry, in the facultative certificate. Quite right, my lord. In the facultative certificate, clause 12, page 125, provides that if the company fails to pay all or any portion of the premium due to the reinsurer as provided in this agreement, the reinsurer may cancel this agreement upon 20 days prior written notice. So we say if one were reading these 2 together, if this were the point in issue before this court, one could say, well, one doesn't need to resort to the confusion clause because under the MRC, you've got a date of the 28th, and if you miss that date, it's automatically terminated. If you miss the 1st of September date, well, then the reinsurer has the option to cancel on 20 days' notice. So they can, we say, coexist alongside each other. The second point, we say...
But the point that's being made here is that they're actually different payment dates.
Yes.
And there does seem to be a conflict between them. Because one says the payment date is the 28th September and the other says it's the 1st.
Yes, and I can see that there may, at first blush, if this were the point that were being argued, I can see how my learned friend may say there is a conflict. My answer, depending on what my interests were, might be that in fact there is no conflict, because if one reads the different payment date with the clause in the facultative certificate, the results are different. And so in essence, if you go past the 1st, your reinsurer has the option to cancel. If you go past the 28th, it's cancelled automatically. And we say they dovetail. So
does clause 7 of the certificate provide for interest on overdue amounts? Just looking at that, it says it's payment of loss, but actually the last bit of it looks that it might be saying it works both ways, where either party is the creditor.
I had understood that to be on a failure to pay an indemnity under the policy as opposed to, but I will have another read of it and see if it might do both. Even if it did, no, my lord, that wouldn't, we say, change the position, because one might say, well, I won't exercise my option to cancel. I'll take my interest, and if they still haven't paid by the 28th, well, then it cancels automatically.
Yeah, but they, in one case, they'd be entitled to interest, and the other they wouldn't.
Yes, and they could make that election.
But the outcome is different commercially.
Yes.
So it looks as though there's a conflict.
Well, we say not necessarily so, and we say there is a way that they can be read together. Happily, my lord, that isn't my only point on this. My second point is that alternatively, as the judge found, one might say that the confusion clause does not bite. Because if there is a specifically made amendment to the premium date, one might say, and again, I say we're dealing with relative hypotheticals here, this isn't the point that needs to be decided, one might say, well, there isn't confusion that arises in circumstances where there's been a specifically made amendment. So that might be another way to deal with it. The third point is that we say that this is not, on any view, enough to tip the balance. Even if I were wrong on points 1 and 2, it does not undo the clear language of the clause. It does not undo the commercial considerations. It does not undo any of the factual matrix. Now, I appreciate that might be considered the legal equivalent of a shrug of the shoulders, but we do say that that is the result when one comes down to it. One can read it together. If you're not with me on that, the confusion clause doesn't bite. And even if I'm wrong on those two, this isn't enough, we say, to undo everything else and to turn what is clear language in the confusion clause into something else.
So what is the distinction on your second argument? Clause of the certificate which does prevail and a clause of the certificate which does not prevail?
Well, one would probably have to look further into the background, and one would need to say, well, was this specifically agreed and why, and if so, in what circumstances? And the factual background, plus the way that...
It's a very odd way to go about construing contracts. Normally, a contract is a contract. If it's signed, those are the terms. And you don't go delving into the background to find out whether some terms have more force than other terms.
No, but one does sometimes, as a canon of construction, apply the approach that specifically agreed terms will take precedence over not specifically agreed terms. And one would then have to look at whether these were or were not specifically agreed.
But they must have been in both cases. I mean, the date for payment must have been specifically agreed, mustn't it, between the parties? It's not a sort of boilerplate kind of thing, because you have to have one date or another.
Yes.
So in both contracts, they must have been specifically negotiated in the sense you're describing.
I would assume so. One doesn't know necessarily the circumstances in which the second one came about. One might, in that case, take the slightly unusual approach of looking closer at the background factual matrix and finding out.
Thank you.
My lord, similarly with the cancellation provisions, my learned friend didn't go into this in any particular detail, but we say the same three arguments apply. In essence, the provision that's introduced by the facultative certificate is cancellation/termination subject to no losses. The cancellation provision in the underlying contract is that brought in by the general change endorsement. That is at tab 4, page 117. That provides that the policy may be cancelled at any time at the request of the insured. Now again, we say one can read those two together if one wanted to. One could say simply that at any time is a reference to the time period during which cancellation can be exercised, but it is subject to no losses. So one can cancel on the last day of the policy period if there haven't been any losses, but one can't cancel if there have, in month 2, been losses. So we say again, if one was to read them together, one can reconcile them in that way. And as I say, my second and my third arguments in relation to premium payment date apply equally to cancellation. The next point that my learned friend makes is that the facultative certificate is applied as an amendment to the MRC, to the slip. Now, we say that in fact this again points in our favour and not in GIC's favour. We say that the fact that the parties chose to endorse the MRC without describing it as being superseded, or without, in the partner re sense, just simply sending it out and it therefore superseding in that way, suggests to the contrary that the MRC continues to have effect. The endorsement is in the supplemental bundle at tab 5, page 131. And one can see here my Lord Justice Nugee asked about the endorsement. This is the endorsement. This is a GUA, a GUA endorsement. That's essentially a form of endorsement. My lady, of course, will remember all of this from Partner Re, where one has following insurers, so a lead insurer, and then following insurers. And the GUA provides a mechanism by which a contract can be agreed as amended by a lead reinsurer. And it's a particular form. It's done electronically now. And it has this box. It used, I think, to have a stamp. It now has a code, I think, that is entered. And this is what comes out. And we say that it's relevant, that this is referred to by the parties as an endorsement. We say that by endorsing the MRC, one is making clear that it is an addendum rather than a document that supersedes. It is, we say, something that's going to be read with the document that it endorses. We say it would be
What is the UMR?
I think that's unique market reference, which I think is the code that the broker gives to any particular part of the placement.
And what is the number referred to? That's the underlying MRC, is it? Or?
So that is, I believe, so the end of it, the PRPNA 2104091,
That's the number on the MRC.
is the number on the MRC, is the policy number. I believe that when particular other documents are created, they add other letters and numbers to the front of it. So if you had the unique market reference B0713, you would know that that was a form of GUA endorsement to policy number PRPNA 2104091. I'm looking at my learned friend here. I know he gave a talk on the GUA recently, so he will correct me if I'm wrong, but my understanding is that is how those numbers are created.
And do we know what GUA A, essentially the agreement practice, what that means?
That is, I believe, there are different ways that an insurer can bind other insurers, and I think GUA A is the standard way that it's done. I think there are others where you need the following insurers to sign.
So the effect of this is because GIC Syndicate 1947 is the lead underwriter for this layer, all the other, although it only takes 10% of the layer, all the other following ones.
So not quite, because in this case...
This is what concerns me. I don't know enough about the practice.
In this case, they just wrote 10% as an individual line. So one can write 100% with a lead insurer and then have insurers following.
Right.
And they would take various percentages. This is written as an individual 10% line, which, as my learned friend said, can be written up or down depending on if the policy is over or undersubscribed.
Right. So this endorsement only applies to the 10% of GIC Syndicate?
Yes, that's correct.
Thank you. And what do the words endorsement agreement parties only I know what each word means, but I don't know.
So that, I think, is simply confirming that only the parties to the endorsement are bound by it. But of course, in this case, because that party is GIC, and GIC and TICL are the only parties to the agreement, those words are probably superfluous in this case.
If it helps, my lord, at page 26 of the bundle, which is
Yes.
the original slip, it doesn't use quite the same words, but I'm sorry to interrupt, but it refers to other agreement parties for contract changes, good changes only, and it says slip leader only. So,
Yes, I
but,
see.
but it's slightly unreal in this case because GIC is the only underwriter subscribing to this particular subscription risk.
What do you call the 10%? It's not the layer, because the layer
It's a
is
line.
It's a line
Or proportion.
or proportion. Thank you very much.
Sorry.
Not at all. So
I'm just looking at the judgment. The judge said at paragraph 28, the certificates took effect as a GUA amendment or endorsement of the slips, and that's agreed. There's no challenge against that.
no. And that was different to Partner Re, where one of the points was that the GUA was not followed. But we say here, to endorse the MRC with another document would be a very curious way of superseding that document. It is in essence a way of creating an addendum to the slip. And we say that is to some extent confirmed by the submission I've already made on the confusion clause, that refers specifically to the MRCs, which again suggests that they were intended to continue to have effect. So far as this goes anywhere, we say this is a check in TICL's column, not in GIC's. My learned friend, also in his skeleton, but not really pressed orally, suggests that the fact that the facultative certificate can operate as a complete contract of reinsurance is a background fact that might assist in construing the confusion clause. Now, we say the fact that it can operate as a complete contract of reinsurance is not an answer to whether it was intended to do so. We say that when viewed properly in context, this case shows that it was not intended to operate on its own, and that is because the confusion clause refers to it specifically and because it was endorsed. And we refer again to the fact that in the prior year, in Partner Re, the court found that the MRC was not superseded. We say, of course, that the MRC can equally operate on its own. It's accepted, in fact, I think, that it did operate on its own for a period of time. For the 9 days before the facultative certificate was issued, the MRC was the entirety of the policy terms. Had there been a loss on day 4 or day 5, the parties would have settled that loss, or litigated it perhaps, with reference to the MRC, to the slip. We say that that, again, is a check in TICL's column in terms of background fact. It supports the natural and obvious reasoning of the clause. And we also have the point that I've made already that particularly negotiated clauses of the MRC would be lost if the MRC was superseded. And then the final point my learned friend makes by way of reference to other clauses is the entire agreement clause, which I've dealt with already. So we say that taking those in the round, when one looks at it, we say that in fact the points are either neutral, if you're not with me on my interpretation of reading together, the premium payment date and the cancellation clause, or in fact support TICL's reading and what we say the obvious and natural reading of the clause is. That then takes me, I think, as the final point, penultimate point on ground 1, to commercial considerations. Now, it's said on appeal by GIC that the judge did not have in mind commercial considerations. Now, that is not so, And the judgment at paragraph 108, that's in the core bundle, tab 7, page 94. Paragraph 108. The judge did have them in mind, concluded that they were of limited assistance, but goes on to say that so far as they do weigh in the balance, they weigh in my client's favour. The point made by the judge there is as to the likelihood of a particular provision being agreed, and this really goes to the first point that I made. Would one really have expected a clause to work in the way that my learned friend suggests it does, or would one expect it to operate as a hierarchy clause in the ordinary way? Now, I'm not sure if my learned friend pursues this, but it's suggested that that isn't a matter of commerciality that can be taken into account, the likelihood of a particular type of clause being taken into account. We say it is, of course, and I've referred in my skeleton to the judgment of Lord Justice Green in Lumbeck, paragraph 78, where precisely that question was asked. What would the parties have been most likely to agree? But commerciality does go further than that as well. And this is possibly the genesis of my learned friend's submission, that the judge did not take commerciality into account, because below, as here, and as before Mr. Hancock, we made submissions on commerciality. My learned friend says, why would one, and the way it's couched, why would the parties, this was really his serpentine point that he started with, agree a complete contract of reinsurance and then have removed their arbitration clause? Now, our answer to that is, well, that isn't what they did. They agreed a facultative certificate without an arbitration clause because the facultative certificate always had on it the confusion clause, and the effect of the confusion clause was that the arbitration clause just simply never applied. So it's not as though the facultative certificate was endorsed and then the confusion clause was added afterwards. The confusion clause was always on the face of the facultative certificate. So the setup, we say, from my learned friend's point on commerciality is wrong. On the other hand, we have a point of commerciality, which is that my Lord Justice Miles made earlier, which is essentially to say, well, why would the parties agree a contract of reinsurance, that for 9 days was subject to English law and jurisdiction, and then change that to New York law? We say that is less likely. That would be uncommercial, without any negotiation, without any change in the premium or the like. And of course, the premium's calculated with reference to the risk, and the nature of the risk depends to a certain extent on the clauses.
I think the point I made was really echoing what Lord Justice Mayles said in the Partner Re case, that you can look at it both ways. It's sort of odd in a sense either way. You can say, well, why did the parties, having agreed the exclusive jurisdiction clause, then why would they have then done this other thing? Equally, you can say, well, why, having decided to enter into the second contract, would they still want to have the dispute resolution clause found in the first one? I think that's what he said. And he said, well, it kind of comes out in the wash because, and doesn't really help you, because you can say either is a bit odd. I think that's what he says, isn't it?
That is what he says, and I apologise, in which case my point is my point, not
yes,
your point,
right.
my lord. But as to...
But what do you say about his point?
As to Lord Justice Mills's point, we say it doesn't apply in the same way here, because we say here the facultative certificate always has the confusion clause. So on our interpretation, it just simply doesn't arise. We don't have it's odd this way, it's odd that way, because you never have an arbitration clause, because that is the answer. And of course, that wasn't present in Partner Re. And that's why we say in this case, and as the judge found, insofar as commerciality applies, again, it weighs in our favour and not in GIC's favour. That then takes me to my learned friend's final point, which was again, I think, mentioned only in passing, which is the reliance on Gilbert Ash or MUR shipping. My learned friend says that Gilbert Ash ought to be applied in such a way In Gilbert Ash, the principle is that parties who have a valuable right are not likely to intend to give it up, save where clear language is used, and says that the confusion clause needs to be analysed in that way, rather than in a neutral way as to what its meaning is. Now, we say that is wrong for essentially the point that I've just made on commerciality, which is that this isn't a case where the parties agreed a right and then took it away. The right never existed in the first place because of the confusion clause being endorsed onto the front of the certificate. We say that this is the way that it has recently been treated when an argument was made in a similar context in the case of Maloney by Mr. Justice Bright. That is in Authorities Bundle Volume 2, tab 16, page 336. This was a case about a shareholder agreement for a Jersey company, and there was a dispute as to whether, under the interpretation of a particular clause, a shareholder had to be consulted before a deal was done. And at paragraph 96, one can see how the argument is put. Lord Wolfson, King's Counsel for Falcon 7, pressed on me the principle that parties do not give up valuable rights without it being made clear by clear contractual language. That was their intention. However, this principle only applies or can assist where it is first clear that the relevant right exists, either at common law or from some other external source external to the contract, or under the contract itself. It goes on at 97 to explain the nature of the clause in MUR, the right to be paid in dollar currency. It says, in many cases, the unitary nature of this interpretive exercise and the iterative process that it requires makes it impossible to start from the premise that the contract has conferred a right. Very often, one party's approach to the correct interpretation will involve it questioning whether the contract does, in fact, confer the relevant right, at least in some circumstances. That is the position here. I have therefore not gained much assistance from MUR shipping. And we see that's precisely this case. We say the relevant right never existed, so it's artificial. However, insofar as one might say that it does apply, we say, again, that it would support our case, because what isn't in dispute is that there was an English jurisdiction clause for 9 days. That is the clause that's being given up. That is the valuable right, the only valuable right. The other way of looking at it is the way the judge looked at it, which is to say, well, both rights are valuable rights. This isn't a case where one has, for instance, cover given by one clause and then taken away by an exclusion. These are two parties. This is a conflict, and this is what we say is precisely the scenario that the confusion clause was designed to address. And so one ought to simply apply it in the usual way. So, my lady, my lords, we say that the language of the clause is clear, and its meaning would be clear to any ordinary reader. We say that none of the extraneous interpretation points serve to change that clear language, and indeed we say all are either neutral to or positively support TICL's natural reading of the words. We say that the factual background in Partner Re, insofar as it's comparable, supports our reading. We say HIH is inapposite. We say that the other terms of the facultative certificate are either consistent or neutral. We say that commercial considerations weigh in our favour, and we say that Gilbert Ash does not apply. Insofar as it does, it supports us. My lady, my lords, unless there are any questions, that concludes ground 1. I was going to move on to ground 2.
Thank you.
So, ground 2, we say, first of all, it is important, as I think the learned friend accepts, to set out the relationship between the grounds. We say it's important to recognise, as I said at the outset, that we're only in ground 2 if I've succeeded on ground 1. So ground 2 needs to be viewed through the lens of there being a hierarchy clause in the form of the confusion clause. And we say that that is important because, in essence, what my learned friend says is that there are, I hope I'm not doing his submissions a disservice, but he says there are cases where arbitration clauses and jurisdiction clauses have been read together. What we say as our overall submission is in no case has there been an arbitration and a jurisdiction clause read together that has all of the features of this case. There is no case that has had both the clause in two separate documents agreed at different times with a hierarchy clause in circumstances where the two documents apply different governing law and in circumstances where the seat of the arbitration is different from the location of the court. Some of those features have been present in some of those cases, but in no case has all of them been present. And that, we say, is important because this, again, is essentially just a question of interpretation. What would the parties have intended? And one looks to the features of the contracts in order to determine what they intended. And we say that stacking them up together, those 5 features that I've just listed, clearly, we say, militate against the parties intending to essentially not give effect to a hierarchy clause, but rather to read down the jurisdiction clause to being what my learned friend refers to as an auxiliary or supervisory clause. And I should say not supervisory in the sense of it being the curial court, because it's not. Just being supervisory in the sense that it can exercise the powers under the Arbitration Act that it can exercise anyway if an arbitration is seated elsewhere other than England and Wales. We say it's really not fair to be saying that these clauses are being reconciled. I think we ought to face up to what is actually happening here. What is happening is that the arbitration clause is being given precedence over the jurisdiction clause. The jurisdiction clause is being essentially rendered nugatory. There is nothing left of it. Now that, we say, stepping back, would be an odd situation to have where the parties have agreed a hierarchy clause, and a hierarchy clause that gives precedence to the terms of the MRC, to the slip. It turns that clause on its head. And that is why we say, in broad terms, my learned friend's argument can't succeed. Turning then to the slightly more granular detail of my learned friend's argument, as I understand it, the building blocks are twofold. One is to say that there is an approach the court ought to take, that arbitration clauses ought to be construed broadly. And the second is to say that the court should strive to not find inconsistency between the contractual clauses, between various contractual clauses. Now, I should say at the outset that I don't accept that even if I'm wrong, that both of these foundational assumptions do not apply here, that the result is any different. We say as a matter of question of construction, all of the features I've outlined already make it clear that in this case, the parties intended the jurisdiction clause to prevail. But I do go further than that and say, in any event, those foundational assumptions are incorrectly applied. Now, as to the question of whether an arbitration provision should be broadly construed, that, I think, was given life to in ACE, judgment of Christopher Clark, Mr. Justice Christopher Clark as he was. That is at, I think, paragraph 76, which is in Authorities Bundle tab 3, volume 1, page 99. Now, the bare statement is at paragraph 76. It said on both sides of the Atlantic, the first is that the article was agreed in the context of a strong legal policy on both sides of the Atlantic in favour of arbitration. Now, that is the bold statement. But what underpins that statement is then explained at paragraph 77 and 78, where Mr. Justice Christopher Clark refers to the premium NAFTA decision, the Fiona Trust, as it's normally referred to, decision, a presumption that sensible business people are likely to have intended all of their disputes to be heard in one forum. referred to also at 78, Lord Justice Bingham's enunciation of the principle of Asplin investments. Now, we say that the statement that there is a presumption in favour of arbitration has to be read in that context. So where an arbitration clause applies and what is in dispute is its scope, then there is, we say, a presumption in favour of arbitration, and that is because it gives life to the principle that parties are unlikely, absent clear language, to have intended disputes to be split across different forums.
It's a one-stop shop.
Precisely. And so where you've got a conflict between a jurisdiction clause and an arbitration clause, and one asks, where does this dispute go? Then one does give the arbitration clause a wide meaning. But where the question is different, where the question is, does this arbitration clause apply at all, then there is no presumption. And that is also important when one looks at the foundational justification for arbitration. It's a consensual process. The courts enforce arbitration agreements because parties have agreed to arbitrate. So if one is looking at the question of did they agree to arbitrate, of course one has to approach it neutrally. One can't approach it with a presumption. It's completely different where a party accepts they've agreed an arbitration clause, but what is in question is the scope of it. And so, for example, in Fiona Trust, the question there was not whether the arbitration clauses were binding, but whether they were wide enough to cover claims of bribery. No party said the clauses weren't binding. In Surrey and Suez, and this is a point of distinction, again, the parties agreed that the arbitration clause was effective. What was in dispute in Surrey and Suez was its scope. So my learned friend took you to some passages of that judgment. If we look at paragraph 48, which is in volume 2 of the Authorities Bundle, tab 11, page 240.
240.
Yes, maybe 240. We can see the scope of the dispute set out at 48, and it's at the very foot of page 240. It goes over to the next page, 241, and it starts halfway through the paragraph with the words, there is no dispute between. Because there is no dispute between the parties in this case that clause 52, that's the arbitration clause, of the WDPA, that's the waste disposal project agreement, which provides for arbitration, remains operative. So the first element is therefore demonstrated. I'm sorry, I should have started at the start of the paragraph, which is the first element, is that the arbitration agreement exists. Secondly, that it's applicable to the dispute. So essentially the distinction I've been discussing, does it apply? If so, what does it apply to? And it's said here that the first element is demonstrated. In other words, the parties agree there's an arbitration agreement. Accordingly, the sole question concerns the second element. What is its scope? Now, my learned friend, I think, only relies on Ace, Fiona Trust, and Surrey and Suez for this proposition. It's raised again in Sul America. Sul America is also a case where there was no dispute that an arbitration clause had been agreed. What was said by the party in that case was that the arbitration clause was at their option because Brazilian law applied, and Brazilian law treated the contract as a contract of adhesion, and so the insured had the option to arbitrate or to go to court. But there was no dispute that the arbitration clause had been agreed. So we say that this is not a case where the assumption applies. The second point that my learned friend relies on to build his case is to say that the court should strive to read clauses of a contract together. Now, we say that that is not the case where there is a hierarchy clause. Now, in Surrey and Suez, where there's a summary of the principles at first instance, it might, if one were reading it in isolation, suggest that the first step is to strive to read clauses together. But that's a summary of what's gone before, and the authority that's referred to for that proposition is Alexander and West Bromwich. That is in the Authorities Bundle, Volume 1, tab 7, page 159. And you can see paragraphs 33, 35 and 36. I think this is with reference to Lord Justice Bingham's judgment in Pagnan and Tradex. And this is considering specifically our case, so a contract that contains a hierarchy clause. And it said there, Lord Justice Bingham pointed out at 574 that it would be wrong to approach the contract on the assumption that there is no inconsistency, since by including the inconsistency clause, the parties have acknowledged that there may be. At 35, said it. Okay, so my learned friend would like to read 34. On the other hand, Lord Justice Bingham observed that it would be wrong to approach this question with any predisposition to find inconsistency, since the clauses are all part of the same contract, and the parties chose to make the contract subject to the printed standard conditions. It's then said 35, where there is an inconsistency clause, one should therefore approach the question of inconsistency without any preconceived assumptions. One should not strive to avoid or to find inconsistency. Rather, one should approach the documents in a cool and objective spirit to see whether there is inconsistency or not.
Are there any documents that should not be approached in a cool and objective?
Well, apparently one's without an inconsistency clause. Thankfully, I suppose for the temperature in this courtroom, this one does have one. So what we say is that it is wrong to say that one strives to find consistency. One doesn't strive to find consistency, one approaches it neutrally. And so the approach taken in Sul America, which my learned friend relied on, which was to essentially, and on Mr. Justice Cook's own admission, essentially leave the arbitration clause with no meaning, no real effect or meaning, is not one that this court needs to apply. Because one doesn't apply a presumption in favour of arbitration, one doesn't strive to read them together.
There was no inconsistency clause in hierarchy clause in Sul America.
Precisely, my lord. And because there was no hierarchy clause, Mr. Justice Cook was left with no other option, and he accepted that in his judgment. He said there was no other option but to essentially read down the jurisdiction clause. That isn't the case here because there is a hierarchy clause. And we say that reading the documents fairly, one would be doing some considerable violence to the parties' agreement if one were to turn the confusion clause on its head by essentially rendering the jurisdiction clause entirely without meaning.
I think he said, didn't he, in that passage, that if he didn't read the clauses in that way, it would have ended up with two different shops.
Yes, precisely. And that is because, to my first point, Sul America was a case where both parties accepted there was an arbitration clause that had been agreed. So it wasn't a case where the threshold question was, has an arbitration clause been agreed? That is not a problem here, because that is the very dispute that we are having. And so there is no need to undertake those contractual interpretation acrobatics to read down the jurisdiction clause and to pretend that in some way that is reading them together, because that's what the parties intended.
It's not, as I understood the argument being put forward by Mr. McDonald-Eggers, not entirely devoid of content, because if you go to New York and get an award, you could then enforce it through action in England, and also you might be able to use some sort of supervisory, English court as some sort of supervisory jurisdiction.
Well, it's devoid of content to the extent that one could do that even if one didn't read the clauses in that way. Of course, under the New York Convention, one could enforce the arbitration clause here. Sorry, one could enforce the arbitration award here anyway. And the steps that the English court can take in support of an arbitration seated overseas are given to the court by the right of the Arbitration Act, not by reason of this clause. So it does, we say, read down the jurisdiction clause entirely, because what you're left with is what you would have anyway. So in that sense, what we do say, it renders it with nothing.
And would, this may not be a question for you, but would it mean, if you did try and marry them together in that way, so that the English court had a supervisory jurisdiction over a New York arbitration, that the rights of the New York courts to exercise supervisory jurisdiction over an arbitration taking place in their own jurisdiction were excluded?
I suppose first, I don't think that that is being said. Second is, I think that internationally, from a perspective of comity, it would be...
It'd be quite difficult, but that means you're not really giving the English courts exclusive jurisdiction.
Of course, and that is the point we're saying. We're saying that there is no exclusive jurisdiction. So reading the clause in the way my learned friend suggests turns what was for 9 days an exclusive jurisdiction clause in favour of the English courts into nothing. It turns it into a fallback on one's rights under the Arbitration Act, for which one doesn't need a contractual agreement.
And again, this may be really a question for Mr. McDonald-Eggers, but what is the force in those circumstances of the provision that the contracts governed by English law?
So we say again that is one of the factors that we say plays into this. We say that because of the fact that the jurisdiction clause and the governing law clause are the same clause, that it's difficult to divorce the two. And so we say that is another factor that makes it difficult to read these two together, because the facultative certificate purports to apply New York law, not just to the arbitration agreement, but to the insurance.
It's the governing law. There's a separate clause saying it's the governing law.
Precisely.
And you say that's excluded by the confusion clause in favour of English law?
Yes, we do. And that was Lord Justice Miles's conclusion as well in the prior year in Partner Re. And that is also the conclusion of the judge below. Strictly not a finding that needs to be made, but is one of those factors that one can weigh in when one's looking at the contractual structure as a whole to say, does this or doesn't this work?
Well, it may be relevant to the question whether you can marry the two clauses and give some content, because it is quite difficult to see how you can have the same contract governed by two different governing laws. Well,
Precisely, my lord. And
it's not entirely impossible. I saw a contract once which said if you sue in Germany, German law will apply, but if you sue in New York, New York law will apply.
Creative.
Yes.
But I think Mr. Justice Foxton on the ex parte hearing described applying two different governing laws as a paradigm case of confusion when discussing the confusion clause. And so
and it's not an answer to say that in most respects New York law is similar.
No, it isn't. And in fact, we would say, and I appreciate there's no evidence before the court on this, but we would say that because of the Insurance Act in England, the terms of the insurance are different because one applies the terms of the Insurance Act to the reinsurance. So all of the provisions on non-disclosure and misrepresentation and the like are governed by the Insurance Act. There is no equivalent in New York, not in the same terms. And so one would be...
Excuse my ignorance, what date is the Insurance Act?
It is, you'll forgive me, I think it's 20...
It was a fairly recent one, wasn't it?
I think
It's 2015.
2015, but it didn't come into force until 2016.
That's fairly recent for me.
So we say that the foundational assumptions don't apply, and we say that the other cases are all distinguishable because none of the other cases, Surrey and Suez, or any of those others that my learned friend relies on, which refers to as a plethora of cases, have all of the features of this case, which all, as I said at the outset of my submissions on this ground, tend to suggest against the parties intending a construction that reads those two clauses together. My learned junior, Mr. Partridge, prepared what I hope will be a useful table appended to the back of our skeleton, which sets out the cases that my learned friend relies on and highlights the distinguishing features between them. So notes if there is or isn't a hierarchy clause, if it is a two-document case, if there is or isn't a different governing law, if there is a different seat to a different court. None of them has all of those. And we say all of those together put it beyond doubt. And my learned friend's reliance on specific cases where specific approaches have been taken is to some extent an unhelpful comparison, because those are all questions of construction on the facts of those cases. This case is different, and this case, we say, clearly suggests that the clause cannot and should not be read together. And this is something that 2 years ago, when the ex parte application was made, Mr. Justice Foxton addressed in his ruling, and that's in the supplemental bundle at tab 7, page 150, paragraphs 28 and 29. And Mr. Justice Foxton said the court must be wary when reading a term in a primary contractual document with a term in a contractually subordinate document together, that you do not end up with something that would fundamentally change the meaning and effect of the term in the primary document. For that reason, I have refused to read two exclusive jurisdiction clauses together to create a choice of exclusive jurisdiction in generali and pelagic fisheries. And it seems to me that to try to read the arbitration agreement in the subordinate document together with the English jurisdiction clause in the primary document here would fundamentally change the meaning of the former. And we say that that submission, or rather, sorry, that finding, stands true when made as a submission by me today, 2 years later. One simply cannot read these two together without essentially inverting the parties' bargain that they have struck. My lady, my lords, I wonder if I might just check if I've missed anything. I hear the rustle of post-it notes behind me. My lady, my lords, unless there are any questions, those conclude my submissions on ground 2.
Thank you very much indeed. Mr. McNulty-Eggers.
Thank you very much, my lady. I'm going to make a number of points. They may seem quite disparate. They don't follow any internal logic of my own. They just follow the logic of my learned friends' submissions, which is not to say they don't have some logic. They do, but...
Which isn't to say that his submissions were.
Now, they're not serpentine. They're very clear. The first point I wanted to make is, insofar as I did create confusion concerning the incorporation of either the underlying primary reinsurance wording or the original policy wording, of course I apologise, but that does not affect my submissions at all. It makes no difference in that context.
It is the primary layer.
It's the primary layer. My learned friend refers to the fact that there was a general change in endorsement, which includes, for example, the communicable diseases clause, and that somehow had an impact in terms of the analysis which is to be undertaken. Now, I appreciate, of course, this was done, considered by Lord Justice Mayles in the Partner Re case, where there was no confusion clause or hierarchy clause, or whatever you want to call it. But it's worth just pointing out what Lord Justice Mayles said on that particular occasion. And it's the second bundle of policies at tab 13, page 272. Paragraph 58. Lord Justice Mayles says, Mr. Killen submitted that the MRC, the slip, contained various bespoke clauses which the parties had negotiated, while the MURA, the certificate, was a document in standard form. The parties would not have wished to sweep away these terms which were not included in the MURA, and that this demonstrated their intention that the terms of the MRC should prevail. However, most of the terms which were attached to the MRC were standard market wordings which were not the subject of any individual negotiation, while the MURA achieved essentially the same result by the mechanism of incorporating the terms of the direct insurance. Ultimately, it appeared that there was only one potentially significant term contained in the MRC, which was not carried over by one means or another into the MURA. This was the Partner Re's communicable diseases clause. On the other hand, the MURA contained a potentially valuable clause giving each party a right to inspect the books and records of the other, which was not included in the MRC. In my judgment, the communicable diseases clause is a flimsy basis from which to deny that the mirror was indeed what it purported to be. And what we would say is, of course, in this particular case, the existence or non-existence of the confusion clause doesn't affect the considerations made by Lord Justice Males, expressed by Lord Justice Males on that occasion. My learned friend, I did make the submission earlier that absent the confusion clause, I had understood that it was common ground that the certificate superseded the slip. The reason I made that submission is because that was a finding of the judge below, paragraphs 88 to 96 of his judgment. And there was no response notice served by my learned friend. There was no indication that that point was going to be contested. And in those circumstances, I didn't realise it was a point which was still alive. But even if it was a good point to make, in terms of being open to my learned friend to make it, I don't think it changes anything. The fact is, given the nature of the certificate, absent a confusion clause, for the reasons given by Lord Justice Males, it must supersede the slip. And it's very hard to see why it would not.
Yes, I'm just trying to get my head around whether a respondent's notice would have been necessary. It's not obvious to me that it would. I don't think you need to challenge by way of respondent's notice every passing observation of a judge. You need to challenge his conclusions and reasons for reaching the view he does. But I don't think that means every little step in the reasoning. But well, it probably doesn't matter.
It probably doesn't, and I don't want to press it too hard because I don't want to appear unkind. But the fact remains, it was a large point disputed and debated before the judge, and it was if my learned friend wished to say the judge got that wrong, he may well have succeeded without the confusion clause. The next point I wanted to deal with is my learned friend, referred to the well-known rainy sky principle, where you have two constructions available to you. The court's entitled to choose the one which makes most business sense. Having said that, it should be understood, as Lord Clark made clear in that decision, that that's only if there's a genuine ambiguity. So you go through the whole process of construction, you're left with two meanings which are equally applicable, and then the court's entitled to choose one which is more business friendly. But it doesn't mean that that's necessarily a consideration which leads you to decide whether or not there's an ambiguity. I think my learned friend said he was struggling to find a confusion in the present certificate in this case. I'm not suggesting there is one on my construction. All I'm saying is that this is a provision set and agreed between the parties on my construction, which would allow the parties and the court, if necessary, to go to look at the slip to answer any questions as to what the effect of the confusion is. Doesn't mean there is one. It just means this is the parties looking forward to providing a self-help mechanism which would answer that particular question. My learned friend made some point about the syntax of the confusion clause. Well, I say that doesn't really go anywhere. The key point here is there a confusion? And if there is, then one looks to the slip. That's when it takes precedence, and that's as simple as that. It doesn't matter if the words takes precedence comes first or comes last in the clause. It still has the same effect. So I'm just pausing to read my handwriting, so just one moment. Oh yes, my learned friend referred to, I think, a couple of passages of Miss Justice Cook's decision in Sul America as examples of this scenario where the judge was using the word confusion to describe a conflict or inconsistency. I would ask you to look at those passages again. I think what the judge was doing, was saying, well, if the result of the construction is X, then that may be a recipe for confusion. It's not necessarily saying or likening an inconsistency with a confusion. And as I said before, you still have the principal submission I have made, which is just because one recognizes that there's a premium payment date in the certificate, which is different from that in the slip, doesn't mean one's confused. One recognizes the conflict. Obviously, the question is, in those circumstances, what one does about it. But it doesn't necessarily mean there's a confusion. I think my Lord Justice Nugee suggested, well, what happens if you just drop the words in case of confusion, the answer is what would happen then? Do you need those words? And of course, in one sense, it may give you a different answer, in the sense that it might be treated as a hierarchy clause of the sort my learned friend was submitting. But those words are there, and one can't ignore them. And I would go further. They are intended to be narrow in scope because of the required terms provision, because of the entire agreement clause, and because that the certificate was entered into as an amendment or endorsement within the meaning of the general underwriters agreement, which is understood to change what has been agreed before. So you take those matters into account, and in those circumstances, I would say that in those circumstances, you use those matters to construe the words in case of confusion. And I say they support my construction for the reasons I hope I've explained. I think my learned friend also made a point about the impact of the entire agreement clause. And I think he said, and if I've understood it correctly, that somehow or other the slip is an endorsement to the certificate, and therefore the entire agreement clause embraces the slip. That's just wrong. It's the certificate which is an endorsement to the slip. It's not the other way around. Now, he's right to say there is a reference to the slip, so it could be said to be an incorporation by reference, but that's only if, on my construction, if in the case of confusion, nothing else. Yes, I think my learned friend also added, look, even though I put a lot of emphasis on the phrase required terms and conditions in the certificate, it's followed by enumerated provisions, which he describes as standard terms. Whether you describe them as standard terms or not is irrelevant. What you do have on that page are required terms, which refers to the arbitration agreement expressly, then followed up by the premium payment date expressly. They are specific terms referred to. Mr. Lord Justice Mayle said they, particularly the arbitration agreement and the other terms in the mirror, are understood and known to those in the market, brokers and reinsurers, and I would add also insurers. And in those circumstances, given the placement of required terms immediately before the premium payment date, given the fact that they're specifically enumerated as incorporated, one can't downgrade them just because one might be able to describe them as standard. They are it's be entirely different, perhaps, if all the certificate said is the mirror is hereby incorporated, full stop. That's a different scenario. But here we're talking about where the arbitration agreement is specifically identified immediately before the premium payment date. Now, just on the premium payment date, while I'm there, the fact remains that there is an inconsistency between the due date or the payment date in both documents. There's no way around that. I think my learned friend was trying to say, well, the remedies available for non-payment somehow cohere. I'm not sure that even that's right, because in one case you've got automatic termination on the 28th of September, whereas if non-payment on the 1st of September allows you to terminate after 20 days' notice, that doesn't take you to the 28th of September, it takes you to the 21st of September. But in any event, whether you terminate or not, the fact remains you can sue for a debt on the 1st of September if it's due, or on the 28th of September if it's due then. They are inconsistent. They are irreconcilable in those circumstances.
Is the payment due date under the slip 28th of September, or is it 1st of July?
28th of September.
It's 90 days.
90 days after.
Then is the force of the words on page 24, premium due at inception.
So where's, I'm sorry, my lord.
Page 24 of the supplementary bundle.
Page 24.
Page 24.
So when it comes to premium premium, the earned date and the payment date are two different things.
But due at inception doesn't mean payable at
No.
conception.
So due means earned. So and the general rule is in insurance contracts, premium
Once you're on
fully
cover,
earned.
yes, subject to provision saying you can cancel.
Of course. And occasionally you see also, I mean, for example, it would be fully earned, but you may have the entitlement to pay on quarterly basis. So it's fully earned on first day of cover, but you pay every quarter. So there is a distinction, well recognised, I would submit, in the premium authorities. They're not authorities I would recommend anyone reading, but they're still there.
Thank you.
Thank you.
But due doesn't mean due, it means
No.
that.
Oh, at least that's my submission.
Anyway, it doesn't matter for your argument, because on any view it's not the same in the certificate.
Correct. Moreover, on the cancellation provisions, you do have a cocktail of different clauses, because you do have the cancellation provision in the original policy wording, which is there, which is under the first layer, and that doesn't disappear. It's there. There is a crossed out version in the slip, but that's only because the 90-day notice of cancellation provision is expressly referred to in the conditions as incorporated in the original policy wording. That's the slip, and then you have the position in clauses 11 and 12 of the certificate, which make very different provisions. Plus, you also have one of the three specific amendments, which is cancellation only subject to no loss. I'm paraphrasing, but that's essentially.
Is that inconsistent with anything?
Yes, because it's imposing an additional condition on when cancellation can be exercised, or rights of termination can be exercised. So the way I read it, perhaps it's best to look at it. If one goes to tab 5, page 121 of the supplementary bundle.
I don't think there's any dispute as to what cancellation subject to no loss means.
No.
It means if you've already had a loss, you can't cancel.
Correct. But arguably, it may be a dispute in itself, but arguably it refers to the right of cancellation by either party.
Yes, I see.
So what it's doing is imposing an additional condition before there can be a cancellation or a termination. Now, the point about this, of course, just like as with the premium provision, clause 2 makes no relevant exception in case of confusion. Now, my learned friend's case, if that's a conflict with the original slip, why does one exclude item 3? Why does one exclude the other cancellation provisions, and why does one exclude the premium payment date? There's no answer to that. If the answer is...
Well, there are 3 answers, but you say there's no good answer.
No good answer. Well, one of the answers given, which I think is the one which carries more substance, is that it's a specific subsequent amendment. But in those circumstances, I don't see why the required term as to arbitration should be treated differently, bearing in mind it comes immediately before premium payment. I'll come to another point which my learned friend makes, I think, in the context of ground 2, but I'll just make it now. Somehow or other, I think what my learned friend is saying is, well, you've agreed English jurisdiction to begin with. There is this hierarchy clause on the assumption he's right about ground 1, but there's this New York arbitration agreement, but that is also an agreed provision. The parties have agreed it. So the only reason one would disallow it is if the confusion clause were to apply to disallow it. But nonetheless, the parties clearly had it in mind, referred to it as a required term. And the only question really is, how does one reconcile those two provisions, if at all? And that's a matter of court. Just in relation to the GUA, the General Underwriter Agreement endorsement, this was a matter which was discussed by Lord Justice Mayles. It's in paragraphs 61 and 62 of his judgment, page 272. I'm not going to turn to it now, but as far as the debate we have today, I certainly don't think it supports my learned friend's case. If anything, the reason I've referred to it, and I just want to make it good because it may have been misunderstood, not least by myself, but which is that when one has an initial contractual document, I won't use the word slip, subject to amendment pursuant to a general underwriter agreement mechanism, which this is, and it's a well-known mechanism, the obviously the expectation is that the later endorsement amending the prior document will do just that. It will change whatever rights and obligations previously existed. So that would be the expectation if one agrees a certificate pursuant to the GUA endorsement mechanism, which happened in this case. And I would add, of course, the parties fully understood that these certificates were to be issued even before the slip was signed. That's evident from the chronology, and it was the same position in the Partner Re case. So in those circumstances, that is why I say, if the intention is to undo the amending effect of the certificate as a GUA endorsement, you would expect to see clear language to achieve that end. Because otherwise you are upending the whole GUA system. Now, as far as...
I thought we were told, tell me if this is wrong,
Yes.
that in the slip, the clauses are all bespoke clauses, they're all populated, there aren't standard terms.
And that's normal for a slip.
Yes, and one of those, obviously, is the governing law and jurisdiction clause. Why? Because as you pointed out on the chronology...
I'm sorry to interrupt, my lord, but when you say all, I mean, there are terms referred to as incorporated in the underlying original wording, which include market wordings as well. So you can see that, for example, at page 4. I'm sorry to interrupt, but at page 4 you'll see, for example, at the very last line, LMA 3100, sanction limitation exclusion clause. That is a standard clause. That's a market wording.
I see, I understand that.
And there are other examples throughout this document.
But the jurisdiction clause, why would the parties agree that if, as you pointed out, they were expecting the certificate to come in due course, and you told us that the evidence was that the certificate was a well-known...
well, Lord Justice Mail said that in the Partner Re.
Yes, exactly. So why would you, if you know you're going to get a certificate with the New York Arbitration Commission, why do you agree English law in the first place?
Well, this is Lord Justice Mail's, and I think my Lord Justice Miles' point. But it can go either way. It's one of those, those unlikelihoods which can be argued in support by other parties. All I can offer is this: that this is the slip was agreed for subscription in the London market, and one would normally default to an English law and jurisdiction provision for use in the London market. Once you realise, however, we need a reinsurance certificate which adopts the North American standard form relating to a risk underwritten in the United States. So remember that it's the scope of the property.
So I think this might be straying into evidence.
Well, I think
the judge did find that it was a bespoke provision for jurisdiction, so
I think my lord asked me a question. I was offering a...
Yes,
yeah. And that's why one would see the New York law and arbitration provision in the Mura form. That's the only suggestion I've got. But as my learned friend quite rightly points out, I'm not a witness and I have no evidence of that. That's just my supposition.
Thank you.
Now, as far as ground 2 is concerned, the point obviously which has been made is that the confusion clause presupposes that it applies in the context of a conflict between the slip and the certificate. This assumes I'm not successful on ground 1. Now, I think one of the points my learned friend made was, well, wait a second. That really does cut down the nature of the jurisdiction of the chosen English court from the slip. But the fact that there may be little or no jurisdiction left to exercise was not a reason to dissuade the court in both Sul America and also in Surrey against Suez to conclude that's exactly what the parties have agreed. So to give primacy to New York, arbitration agreement, but to allow some supervisory jurisdiction to the chosen court, even though it may be very little in practice. And that's paragraphs 91 of Surrey case and paragraph 49 of the Sul America case.
I mean, in Surrey it wasn't quite the same, was it? Because it's all going to be English law.
It's going to be, everything was going to take place in England. Is that, and
under English law.
Yeah.
And one can see that, and supposing there is some sort of, there's a recognition that arbitration is important, and the courts will seek to uphold arbitration agreements. You can see that you might say in that situation, well, the English court still has some supervisory jurisdiction. It's a bit more difficult, isn't it, where they've agreed English exclusive jurisdiction and English law, and then to give that any meaning when there's going to then be a New York arbitration with in the sense that the seat is in New York, and indeed the governing law of the contract is New York law. It's very hard to see what's left of the exclusive jurisdiction clause.
Well, the two answers I have to that, just because there's very little left is not a reason not to make a finding that the two provisions can't be reconciled, because that's exactly what Mr. Justice Cook and Mr. Nissen both said in their respective judgments. As regards my Lord's question about governing law, one should remember what Mr. Justice Cook said and did in Sud America, because that was even though there was a Brazilian law overriding agreement to apply to the contract itself, there was a Brazilian jurisdiction agreement and there was a London arbitration agreement. The judge held that as far as the London arbitration agreement is concerned, that was governed by English law, even though it wasn't expressed by the parties. So he made this division, and that was supported by the Court of Appeal on appeal. And the mere fact, therefore, that the seat of the arbitration and the choice of jurisdiction are in different countries was not a reason to stand in the judge's way of finding a reconciliation between the two provisions. And that's exactly what he did. And of course, the difference here is the seat of the arbitration is not England, it's New York, and the position is reversed. But I say that shouldn't make any difference. There should be no, if you like, predisposition to support English arbitration over New York arbitration. Yes, my learned friend also made a point about the fact that for example, in the Surrey against Sewers decision, parties agreed that there was still an operative arbitration agreement, although I think the argument was it didn't apply to the particular dispute which arose. I would say that the fact that the parties acknowledged that there was this arbitration agreement still in play doesn't detract from the analysis that the two provisions can be reconciled. Just because it wasn't argued, maybe it didn't need to be argued in those circumstances. But the fact is, the undeniable result of the decisions of Mr. Justice Cook, Mr. Nissen, and the courts in the other cases, is that you do have these two provisions, which are brought together, assigning a particular role to the chosen court, which is supervisory or auxiliary jurisdiction, and a particular role to the arbitration tribunal, which is obviously dealing with a substantive dispute. And insofar as English law is chosen for one and New York law is chosen for the other, it's not difficult to decide how those laws should be divided. English law to govern the supervisory jurisdiction, and New York law to govern the substantive jurisdiction. But that is a matter for argument if and when the issue arises at a later date. Yes, I think my learned friend, almost closed his arguments by referring to Miss Justice Foxton's decision at the ex parte hearing. Of course, I wasn't there, nor was any of the representatives of my client, so none of the points we would like to have made could be made on that particular occasion. But, I mean, Mr. Justice Foxton assumed in those circumstances that there was a subordinate document and a superior document. And that's not necessarily gives you an answer to whether or not these terms, whether it's to jurisdiction or choice of law, cannot be reconciled. So I would say, even though there is a hierarchy clause on the premise that ground one is unsuccessful, one should not be disposed to find an irreconcilable inconsistency because that is not the approach the courts have adopted. The courts ask the question, is there such an inconsistency? And if there is, then you apply the hierarchy clause. And if you do apply the hierarchy clause in those circumstances, I would submit New York law and arbitration is the answer to the question. Excuse me, my lady, my lord, just one moment. So I think just one. I think I made this point, but maybe I didn't make it as well as enough because my learned junior says I should be making the point clearer. I think Mr. Killen said that the parties never agreed New York arbitration because of the confusion clause, because of its application. I don't think that's the right way of looking at it. The right way of looking at it is they did agree New York arbitration. They did agree, obviously earlier, an English jurisdiction agreement. The question is, does the New York arbitration agreement survive by virtue of the confusion clause? That's the issue. But they did agree it. It's because it's referred to expressly in the certificate as a required term. And the only question is, what's the effect of all that? And then you get back quite neatly, I would say, well, perhaps not that neatly, to my serpentine point, which is why, if you're going to agree English jurisdiction in those circumstances, it's a very old way of doing it. So for those reasons, my lady, my lords, I would ask the appeal to be allowed. Unless there's anything further I can help.
No, thank you very much indeed. And thanks to everyone, both the very helpful and detailed submissions that we've received, and for those who have no doubt put an enormous amount of work into this in the rows behind. So thank you very much. You'll be relieved to hear that we're going to reserve our judgments. You'll be fully aware also that in this court, the practice is that we circulate draft judgments. We do so subject to an embargo. Please be very careful to abide by that embargo. And we also circulate them for typographical errors and perhaps our grammar and obvious factual mistakes, but not for re-arguments. Thank you. And we always hope that you might be able to agree an order, and if you can't, please make very short written submissions and we'll decide on the papers. Thank you very much indeed.
Court rise, if able.